Hi everyone. Today's topic is mandated reporting, child abuse, and neglect. So the child abuse mandate specifies that we have an ethical and legal obligation to protect anyone under the age of 18 from abuse or neglect. These matters constitute a situation of reportable abuse, which is regulated by the law and our ethical codes. The practice of mandatory reporting is essentially designed to encourage clinicians to report any suspected cases of child abuse, and therapists are advised to err on the side of reporting in uncertain circumstances. So when you're not sure, it's encouraged that you at least call and consult or report rather than thinking you don't have enough evidence and not making the report. And it's helpful to think about this as not being intended to punish families or to get them in trouble, but really about protecting the child and other potential victims, and also to potentially help the suspected abuser. Your report could be the thing that brings services that are much needed into the home and brings about positive change in the family. Okay. So in California, the mandated reporting law for child abuse states that if you have reasonable suspicion of child abuse or neglect, you must file a report with Child Protective Services, CPS, immediately. And this is done by phone. So you would call the hotline, the CPS hotline, to make the report as soon as possible. Then you are required to follow up with a written report, which is completed online, and it's called a SCAR, Suspected Child Abuse Report, within 36 hours. So you have these two duties, the phone call to CPS and the written report within 36 hours in order to fulfill your mandate. Okay. Also note that we are mandated reporters as MFTs when we are in our professional capacity, meaning when we are acting as therapists. So in your everyday life, if you observe or hear about suspected child abuse, you're not legally required to report that. You can, of course, and you're encouraged to, but you're not legally required if you're not acting as a therapist in that moment, okay? The states also provide immunity for civil or criminal suits that may arise as a result of your report, meaning that as long as you make the report in good faith and you aren't fabricating information, then if you get sued, you have some protections. So we're going to go over the different kinds of child abuse, and it's helpful to have a firm understanding of what these are because it's your responsibility as an MFT to explain these types of abuse to your clients as part of the informed consent and limits of confidentiality discussion that you have at the beginning and throughout therapy. The first form is physical abuse, and physical abuse involves the use of physical force that often results in bodily injury, physical pain, or impairment. This also includes cruel or inhuman corporal punishment. So this is what you think of classically when you think of abuse, things like bruising of the child, burning of the child, scratching, things like that. In the state of California, certain forms of spanking are also considered physical abuse. So in the state of California, spanking is allowed in very limited circumstances, and I'm going to explain what those are. So children can be spanked with an open hand using the palm on the buttocks, and the spanking cannot leave a mark of any kind. Anything outside of those things, open palm on the bottom, not leaving a mark, anything outside of that can constitute physical abuse and should be reported. Okay, so if an adult or someone uses an object to spank, or they hit or spank the child somewhere other than the buttocks, that is reportable. Okay, so this is helpful to explain to our clients. The next form of abuse that is reportable is sexual abuse. So sexual abuse involves any non-consensual sexual contact with a child. To get more specific, the law specifies that things like incest, oral or anal sex, sexual penetration, lewd or lascivious acts, child molestation, and some forms of statutory rape, more on that later, are reportable. Okay, lewd and lascivious acts doesn't tend to get used in normal terminology a lot, so I think it's helpful to give some examples of that. So that includes things like videotaping children undressing, soliciting prostitution, flashing, and things like that. Okay, so those things are all reportable. Also, sexual exploitation. So this involves things like encouraging children to participate in sexually explicit acts, performances, or depictions. Any behavior like that is reportable. Now, where this gets a little bit complex is with consensual sex with minors, and we'll cover that in the Sex Between Minors lecture. So right now we're focused on non-consensual sexual acts or lewd exploitative acts in this case. Okay, one important addition to the sexual abuse mandate has to do with sexting and digital media, which is all the rage now, yeah? So as of 2015, if you have reasonable suspicion that someone has created, downloaded, streamed, or otherwise accessed images or videos of minors engaging in sexual conduct, you must report this, and it counts as child pornography. So if someone, a client, reports to you that they or someone they know has downloaded or made content such as this, you must report it to CPS. Again, that's as soon as possible, and then a written report within 36 hours. So this gets a bit complex when we consider something like sexting, which is common amongst teens and adults and everywhere in between. So consider, for example, if you have a minor and the minor's boyfriend takes a picture of Consider, for example, if you have a minor and the minor's boyfriend takes pictures of his naked minor partner for personal use. Okay, so naked pictures. Okay. In this case, this would count as child pornography. Even if the boyfriend never distributes those images, you'd still need to report it because it is a photo of sexual content of a child, a minor, okay? Now, if the image or the video is then sent out, the report then is against the sender of the image, which in this case would be the boyfriend, and the person who receives the image, whoever that is, okay? So this is really important to share with our clients who may not view this type of behavior as sexually abusive, but in California, it does count as sexual abuse and it is reportable. Okay, the next type, so we're on type number 3 of child abuse or neglect, is willful harm or endangerment. This involves unjustifiable physical pain and mental suffering. So some examples would be torturing a child with sleep, food, or sensory deprivation. So there are well-known public cases of children being locked in rooms or in cabinets or being starved. All of those abusive acts fall under this category and of course are reportable. I've also personally made reports of children being tied to chairs and deprived of food and water when they misbehave, and that was, of course, reportable. So even though this isn't necessarily physical abuse, it's more deprivation or this willful harm component or endangerment, it is still abusive and it is absolutely reportable. Next is neglect, and this is another form of child abuse. Neglect involves failure to provide adequately for a child's basic needs. So in cases of neglect, the child doesn't actually have to have suffered harm before a report can be made. So for example, if you have a young child who's left at home, say a 4-year-old, left at home alone for a few hours, and perhaps that child managed to not get hurt, like they were in a room maybe and didn't get hurt. This is still reportable because even though that child didn't actually get hurt, there is a very high risk that they could have, okay? So we would definitely report this. It's an unsafe situation. And in a sense, we get to use this as a preventative way in the hopes that they won't be in the situation again and get hurt, okay? Other kinds of neglect would be like not having enough food for the child or water and so on. Medical neglect is included in this category of abuse in some cases. For example, a parent who fails to get medical treatment for a child who's very sick, has a severe cough, severe eczema, and so on, and subsequently their life is potentially at risk, right, with these severe illnesses, this would constitute medical neglect of a child. This would not be the case if it was a preventative type of medical care, such as providing vaccines. So if a parent refuses to provide vaccines for their child, this is considered preventative, and so it doesn't count as medical neglect, despite whatever beliefs you have about that particular behavior. Okay. Also, this is a good place to remind you, if you're unsure with these can get a little fuzzy. Remember that you always want to err on the side of caution, and you can always call and consult. One other thing that comes up a lot when discussing neglect is homelessness. So homelessness is not reportable in and of itself. So we don't report a family for neglect just because they're homeless, okay? Many parents who are homeless manage to provide for the basic needs of their children and are not neglecting their child, okay? So if a family is homeless, don't jump to assume they need to be reported to CPS, but do find out if the needs of the child are being met. Okay, if the needs are not being met, then it's reportable. If they are being met, it's not reportable, and maybe you can help out by providing some resources as well. So if you have, for example, in this case, a child who's malnourished or who's running into the street because they're not being supervised, or the child comes to your session really dirty and smelly because they don't have access to clean water to bathe in, those kinds of things would be the child potentially not getting their basic needs met and could be reportable as neglect, and that would be associated perhaps with homelessness. Okay, next, the last form of abuse is emotional abuse. And emotional abuse, so things like saying really negative or berating things at the child, or withholding affection and care and things like that, are permitted child abuse reports, but they're not mandated. So you may report at your discretion emotional abuse if you feel that it's necessary and that it would be helpful for the family, but you don't have to. You aren't mandated to, okay? If there is some behavioral evidence of the emotional harm to the child or risk of suffering, I would definitely encourage you to report that. It's not as clear cut as something like physical abuse. Again, you can always consult. One thing to keep in mind though is if you do see emotional abuse, like a parent who's just really negative and pessimistic and disrespectful to their child perhaps, be sure to assess for other forms of abuse that you are mandated to report. It's possible that the emotional abuse, the cussing at the child or whatever, likely exists in conjunction with other forms of abuse. So this could just be a warning sign to you that you need to check in for other forms like physical abuse, which you would be mandated to report, okay? So that's emotional abuse. Now, something that I've been talking about this entire time here is reasonable suspicion. And the term reasonable suspicion gets thrown around a lot when we're talking about abuse and reporting. So it's helpful to explain it a little bit. And what I think is the most helpful way of understanding what reasonable suspicion is actually asking yourself a question. And here's the question. If another therapist were in your position, trained as a therapist like you, would that therapist suspect abuse or neglect in this child? Okay. So again, if another person were in your situation, trained as a therapist, would that person suspect abuse or neglect in the child? If yes, then that very likely means there's reasonable suspicion to report and you should move forward with that report. Another thing that might be helpful, and that has definitely helped me in the past, is I can imagine, in session, if I were to call CPS, what would I say about this potential abusive situation? And if I find myself with lots of unanswered questions or feeling like I don't know the whole picture, I need a bit more information, then that likely means you need to assess a little bit further with that client before making the determination about making the report, right? So an example would be if you have a child who has bruises and that's all that you know, right? And so you call CPS and you say, I want to make a child abuse report because my client has bruises on their arm. A likely question that's going to come from a social worker who's taking the call is, where did the child say they got the bruises? And if you haven't asked about that, then you don't have enough information. You haven't assessed enough in order to make this report. You may ask the child and the child might say, I was running and I tripped and fell, right? And then you can follow up with that, all right? Now this is different if you know that there's a history of abuse and you suspect that the child may be trying to hide that information and so on. But the point is, you want to have enough of an assessment completed that you can provide a helpful and informative report to CPS. If you can't do that, you need to assess further. You don't really have the reasonable suspicion quite yet. There's other examples here at the bottom. So if you have bruises alone, as I mentioned, you want to assess further. Bruises in the shape of a hand, clearly that was a hit, right? A slap perhaps. a painful one that left a mark, right? So that would be reportable. If the bruise is suspicious, like it's on the wrists and it looks like perhaps they've been held and squeezed or they've been tied up in some way, that's reportable. Burns, broken bones, and cuts without explanation or with explanations that don't make sense or that continue to happen, definitely reportable. And again, I keep saying it, bottom line, if you suspect, report it. Always err on the side of caution. It's then up to the CPS worker to determine, is there enough to open this case or not, and then to do the investigation. Okay, how do you assess for abuse? In order to assess for abuse, you want to make sure to conduct the session in private and avoid closed-ended questions like, did your father hit you? Right, that could be leading and might mess up the information that you receive from the child. So you want to make sure that you're protecting confidentiality by being in a private place and that you're using open-ended questions like, how did you get hurt? Where did that bruise come from? Okay. You also want to manage your own emotional response. If a child tells you that, that a parent has hit them or that they were deprived of food and you go, you're going to freak the child out and they're going to shut down. Okay, so you have to manage your response. You have to show them that you're not overwhelmed by the story that they're telling you and that they can safely continue to tell you. Don't make unrealistic promises to the child. Don't say, please tell me, I promise I won't tell anybody, in an effort to get the child to explain what happened, because you're lying to the child. More likely than not, whatever it is they tell you, you're going to end up reporting it and they're going to know that you reported it. So don't make unrealistic promises. Okay. In the case of an exam question, don't make assumptions about the vignette. If something's unclear in the vignette or not fully described, then the answer you should be picking is likely assess further. Okay, don't read so far into the vignettes that you see in exams. So let's look at an example, okay? During an assessment with a 7-year-old boy, a therapist observes that the boy is small in stature and appears listless and gaunt. He's difficult to engage in play and mostly unresponsive to questions about school and friends. The therapist notices that the boy is trying to sneak candy from a dish into his pockets. What should the therapist do to legally handle this situation? Okay, so we have some answer choices here. Take a quick note of whatever you need to know from this vignette. Okay, A, comment on the child's behavior. B, call in the boy's mother to tell her about the behavior. C, assess for further signs of child neglect. D, make a note of the behavior and intervene if repeated. So take a moment, pick what you think is the best answer, and then we'll discuss. Okay, so if we go back to the vignette really quickly, we can kind of start to figure out what's going on in the situation. So the child is small and listless and gaunt, so they're potentially leading towards some kind of a malnourishment issue. And then the therapist notices that the boy is sneaking candy, perhaps suggesting that the boy is hungry. And the question is asking what you should legally do to handle the situation. So we're looking for an answer that addresses a legal responsibility in some way. So answer choice A, comment on the child's behavior, does not address the legal responsibilities, right? And just commenting on it, like saying something like, oh, I see you took some of my candy, doesn't really seem like you're addressing the malnourishment and the potential legal responsibilities. So perhaps not the best answer. B, calling the boy's mother to tell her about the behavior. Again, not really addressing the legal responsibilities, and saying that you're just going to tell her about it makes it seem as though you're not going to do anything or that you're not, I don't know, necessarily addressing the concern. So not the best answer. C, assess for further signs of child neglect. So this does get at the potential for neglect with the malnourishment and the potential stealing of food. And the assessment for neglect is a legal responsibility. So this is looking like a good answer. Let's look at D. D, make a note of the behavior and intervene. This has the same problems as A and B, not necessarily addressing the legal requirements and kind of sweeping the issue under the rug, like not really paying attention to it and not looking at all the different signs and trying to figure out, is there a bigger issue here? So C is the best answer. It addresses our legal responsibility of assessing and reporting child abuse and neglect, okay? We're looking at the malnourishment, the stealing, and we're gonna figure out, is there more to this story? Let's assess and see if we need to make a report. So C is the best answer. Okay, I have a couple of special or unique circumstances here, and then we'll do one final example. So one thing that may come up is abuse between siblings. So things like fighting and hitting between siblings, roughhousing, some of which is very developmentally appropriate. Is this reportable because a child is getting hit? Great question. So it is reportable if there's a significant age or maturity difference. So if we have a 6-year-old, for example, and the other person is 17 and they're fighting, that's probably going to be reportable, especially if that 6-year-old is getting injured, right? Or is complaining about pain or feeling hurt. So you can see that that gap is no longer just roughhousing. This sounds like a much more abusive situation. And we would want to, at the very minimum, call and consult. If the kids are about the same age, 4 and a 5-year-old, 6 and a 7-year-old, and they're roughhousing, and from what you can tell, their maturity level is about the same, and there isn't any severe harm, then in most cases, this isn't going to be reportable. Yeah, okay. Abuse of a child who's not your client. So if your client perhaps is sharing about a potential abuse of a child in their life, like a neighbor's child, if it is in your capacity, meaning you're acting as a therapist in that moment, it's your client telling you about their neighbor's child who's getting abused, you must report it. Even though that child is not your client, it's not a child of your client, it is still reportable because that is a protected population and you are in your capacity as therapist, okay? Next, abuse that occurred outside of California. If abuse takes place outside of the state of California and you find out about it when you're acting as therapist, you need to file a child abuse report in the state you're practicing in, meaning California, because that is where you hold your license or your registration number. So if the abuse happened in Oklahoma, for example, and your client tells you about it, if it's a reportable situation, you report it to California, okay? Now, when you call to report to California, they may instruct you to report it to the state that it happened in. You would make note of that, indicate who you spoke to, if they gave you a number, when you called, what they said, and then you would call and make the attempt to report it in Oklahoma and document that. Previously reported, oh, sorry, I'm skipping one. Child being left home alone. There's no real specific age when it's okay to leave a child home alone according to the law, okay? So you really need to take into account, again, the maturity level of the child and the age. So some of them are obvious, right? If you have a 2-year-old left alone, not okay, report it, right? A generally safe age for leaving a child at home alone is somewhere between 10, 11, 12, okay? But again, it depends on their maturity level. You can have a 10-year-old whose maturity level is like 4, right? So pay attention to age and maturity and use that as a gauge for whether or not they should be, it should be reported. Again, you can always call and consult. Okay, previously reported abuse. And I have it in quotations because sometimes families or perhaps even other providers may say that the abuse has been reported when in fact it hasn't. Perhaps even in the case of a family where they think that their previous therapist reported it, but they didn't. So if a client tells you about an incident of child abuse and states that it's already been reported, it is your responsibility to verify with CPS that it has in fact been reported. So you don't get to just write in your notes, oh, it's already been reported, my mandate is fulfilled. No, it is not. You must call CPS, inform them of the abuse, and make sure that it has already been reported. And if they tell you we have no record of this, it is then your job to report it. That is how you fulfill your mandate. Okay, and then the last one is group therapy. So in this particular case, if you're running a group with a co-therapist, so there's 2 of you, and something comes up related to child abuse, a group member shares something that needs to be reported, okay? In this case, you and your co-therapist both have a duty to report the child abuse. However, it can be fulfilled if only one of you reports it. So you can say, I'll report it on our behalf and call and report it. Or your co-therapist can say, I'll report it for us and call and report it, okay? But if at some point you find out that your co-therapist never made the report, it is your responsibility to follow up and make that report. You need to make sure somebody makes it, either you or your co-therapist. One of you needs to make the report. You don't both have to, but one of you must. Okay, so here's our last example. A client reports that she recently awoke in the middle of the night to sounds of crying children in the apartment next door. She went to see if everyone was okay and discovered that the parents had left their 8-year-old, 5-year-old, and 2-year-old home alone. The client suspects that the parents are using drugs and expresses a desire to help the kids. How should the therapist manage the legal obligations? Okay, let's look at the answer choices. A, process the client's feelings about the situation and document the need to file a report in the file. B, discuss ways the client could help the kids. C, inform the client that the therapist must file a child abuse report. D, determine if the children are in danger. Again, so take a minute and then we'll talk about the right answer. Okay, so remember, the question is asking, how should the therapist manage the legal obligations? So just like in the last example, we're looking for an answer that's addressing our legal obligation. And in this case, they're getting at a potential child abuse report related to children being left at home alone. Also remember that we discussed that there isn't necessarily a cutoff for when it's legally okay for a child to be left alone, but we said it's somewhere around 10, 11, 12, and these children are 8, 5, and 2. The 5 and the 2-year-old are especially concerning, right? And the 8-year-old is kind of on the cusp, okay? The other thing to keep in mind here is that the children were crying, so that elevates the risk a little bit because there could be some harm happening. And then another thing is the parents are potentially using drugs, which again elevates risk. So this is looking like enough information to file a report, which would be our legal obligation. So we want to find the answer choice that addresses filing a report. So in this case, we can see that A and C discuss filing a report. The problem with A is it says document the need to file a report, but it never actually says that you're going to file it. Okay, it sounds like you're just going to write it down. And then your mandate is fulfilled, which is not good. So C is the only one that says that a child abuse report will be filed. So C is our correct answer. A and B could be done at some point, but the legal requirement to file a report has been triggered, so that needs to be done first, and you must prioritize that. And then D, determine if the children are in anger. There's already reasonable suspicion. We have a 2, a 5, and an 8-year-old at home alone. As I mentioned, the 2 and the 5-year-old is already problematic, the 8 on the cusp. And then we have potential drug abuse or drug use, and then we have children crying. So that's enough to warrant reasonable suspicion and necessitates a report. We don't need to assess very much further before making the report. So C is the correct answer. Okay, all right, let me know if you have questions, and I'll see you guys in the next video.